Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you? And what happened? Story 1, I had a hearing where the opposing party offered an updated contract that my client supposedly signed, except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself, saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that's a serious accusation. I held up the guy's prior conviction for contract fraud and said, I absolutely am. Your Honor, we won. Hands down, no further argument needed. Story 2, my dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the pie due to de facto marriage. Our claim was that she was a gold-digging who planned it from the beginning. She had mountains of evidence of her contribution to Dad's company and running the private estate. Expense reports, receipts, dates and times her and Dad proved their relationship with trips and combined spending, etc., etc. She had so much evidence, the judge took 4 days to look it all over, after which he came back and basically said, why would you have all of this if this wasn't your plan the whole time? The case was very downhill from there. Edit Jesus Christ weeping bell. Okay, some more clarification. 1. She had done the same thing to her ex-husband, giving precedent. He and her children said, so in their testimonies, one of her children even inadvertently admitted Shed told them what to say and paid them for it. 2. We were able to name the date the relationship between her and my dad ended, which was months before she claimed, and outside the time limit to make it a de facto common law marriage. 3. We had testimony from the doctor at his ICU who said she tried to keep everyone, including his ex-wife, our mother, and us, his children, away from him. Meanwhile, she had his phone and computer and was trying to take over his contacts and business. We had proof of this, for her lawyer was a moron who constantly contradicted himself and the evidence. He lost documents, gave incorrect dates, and asked irrelevant questions of the defense. 5. In the end, it was that her expenses for the relationship were deemed normal for anyone in any kind of romantic relationship, that gifts and meals aren't claimable for compensation, that her contributions to the household and business were not sufficient to warrant compensation. She never actually put any money into either, and that the relationship was not sufficient in duration to qualify as a common law marriage. 6. This case took 4 years to settle, including 2 elevations of appeals. She finally gave up because she had run into about $250,000 of court fee debt, as well as being forced to pay us $40,000. Story 3, I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console in a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments, the DA says this case is a circumstantial evidence case. During my closing, I slapped the jury instruction on the projector that says if a case is based on circumstantial evidence, and there's one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. Edit RIP my inbox. Also, there are some amazing discussions below. That makes me really happy. I responded to as many questions as I had time for. DM me if you have a legal question about this case. Lots of you were interested. So the jury instruction is Courtroom 224, if you want to look it up. Story 4, not a lawyer, but was taken to court once. A guy had taken my family to court. Basically, he had been dating my mother, and things ended. So he then takes us to small claims court with an itemized list of everything had ever bought the entire family. Every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible and ruined other things. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now, he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had and would always talk about his connections and would name drop someone anytime we went anywhere. So when he takes us to court with his full itemized list, the judge asks him to go first and present his testimony. He basically says, while I was with them, I bought all this stuff. I took them to dinner all the time and all this, but it was the idea it would be paid back by them. Judge, you bought a child a birthday cake with the idea it would be paid back. Did you ever say that these things were loans and not gifts? Him, well, no, but it shouldn't need to. That's the normal way people think, Judge. Well, that's not the way ID think. Case dismissed. Story 5, not a lawyer, but took my BL's landlord to small claims court. He's on SSI, and as conservator, we sued her for over $4,000 after she just decided she didn't like him and changed the locks on his apartment door. She also stuffed all of his belongings into trash bags and dragged them out to the curb. This was all done the day after she cashed his rent check. It all started because she was letting herself into his apartment with no notice and was going through his stuff while he was gone. When I found out about this, I told him to let her know that was not okay. He did, and that's why she kicked him out. I'm very organized and presented the judge with a folder containing photos, receipts, short videos on DVD, and the sheriff call logs, as well as a concise timeline of events. The landlord showed up with her son and countersued for the exact same amount we were suing them for, claiming that the apartment was trashed, there were holes in the walls, and they would have to repair everything before being able to rent again. During the hearing, the judge asked for evidence of the damage to the room. The son whipped out his cell phone and showed a video panning and walking around the room. The video showed my BIL's apartment, obviously still being lived in. His stuff was all still there and no visible damage. But there were a lot of posters and things hung on the walls. When the judge looked at the video, he asked, "Where's the damage?" The son replied, "You can't see it. It's behind all of the posters." The judge frowned and looked at the video again, and then said, "Did you take this video when he was still living there at this time?" The son replied, "Yes, this was the clincher." The judge then asked, "Did you ask his permission to enter the apartment to take this video?" Silence. We were awarded the full amount. Story 6, I had to go to court over a financial up. When I was a student, took advice from the university legal support team who said I didn't need a solicitor, so I went in alone. The judge didn't like this and postponed it for another date, so I could prove ID had more counsel first. The other party solicitor caught me outside the court and said I didn't tell you this, and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation that it was right, went to the second hearing alone, and got the entire thing thrown out. The other solicitor winked at me as he left, saved me about $9K. Nice chap. Story 7, not a lawyer, but a relative of a retired prosecutor. Relative was working misdemeanor criminal court. Cases get called in alphabetical order, and two women named Catherine Smith and Catherine Smith were scheduled to have their hearings before the judge. Not their actual names, but you get the point. Both had similar crimes, but slightly different. So the bailiff announces the next case to the courtroom. Catherine Smith for 1 count of possession of cocaine with the intention to sell, and 1 count of prostitution. So Catherine Smith stands up and indignantly cries, whoa, just wait a second. Where did the prostitution charge come from? I may deal crack, but I am not a easiest drug dealing case my relative ever prosecuted. Story 8, actual lawyer here. From the fool for a client file, was interning at legal services after 1L, doing discovery work for family law. My supervisor invited us to observe a hearing for our client to get a restraining order against her husband. At the hearing, the client discussed various times he threatened her. The man, representing himself, interrupted and said, "Judge, I never said any of those things. If I had, she wouldn't be standing here." Restraining order granted. Story 9, not a lawyer, but hey, race a story from the burbs. My buddy is in the middle of a situation like that right now. His psycho neighbor built a wall too high and doesn't have proper drainage on his property for the very small creek natural drainage in between their yards. My buddy hired an attorney as the psycho decided to sue him over it. My buddy's engineer that looked over the property noted not only did my buddy set his yard upright, but the neighbor created drainage problems. Neighbor hired his own engineer that proved my buddy was correct. Now the guy is likely to go postal. Case was going to go to mediation. Since both engineers found fault with the psycho neighbor, my buddy decided he's going to take it to trial, turn the tables a bit. We'll post a follow-up if I can find this thread after the trial wraps. Story 10, my favorite, is a story from Jerry Spence. For those who don't know, he's a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asked the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifts his arm much higher. The jury laughs. The case is over. Edit spelling. Story 11, I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual, but the defense didn't study their chemistry very well and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "OH, I'm sorry." Did you mean carbon monoxide? Because that's a completely different thing, completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel screwed himself by not picking up a book. Edit for clarification, this is not the only reason that lawyer didn't win. There were a lot of other things that didn't work out in his favor, but those were technical things that he probably knew about ahead of time. This was a case where he was asking a question that he thought was going to work out in his favor, but it worked against him because he made a basic chemistry mistake that he honestly should have caught. Yeah, I know he's not a scientist, but you don't have to be a scientist to remember the difference between those two things. Getting terminology correct is part of his job. It's not like anyone caught a felony charge solely because he said that one thing wrong. Story 12, I worked as an intern for a lawyer, construction law. In France, are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360 picture from said bell tower. We as kindly pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. Story 13, actual lawyer here, and this one was especially sweet. Was involved in an ownership control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work and how they are in effect the highest law of the land, which meant the case should be over and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order. Edited for spelling prepping for Irma has left me unable to spell, and to add the following some background, the original Venezuelan High Court order, first order, created the equivalent of a receivership in the company we were representing. The receivership hired us to pursue an unrelated claim here in the States against an American company. The receivership was put in place by the shareholders and the Venezuelan government, as the owner of the Venezuelan company Douchebag was embezzling money and running the company into the ground. There was another firm representing the company before we were hired, and they decided to ignore the first order and claim to the federal court here in Miami that they were the only ones representing the company and that we were the imposters. They argued that the first order was not valid and Douchebag was still in control of the company. There's a second order was the result of an appeal in Venezuela that was very ambiguous in its language and cast some doubt as to the control of the company. Douchebag and his attorneys submitted the first and second order as support to their motion. A third order was issued by a different Venezuelan appeals court, which put the issue to rest. We asked for and received a copy of it. They did not either because they knew it was not supportive of their position or because they dropped the ball. We believed it to be the latter. Our motion cited similar case law and advanced the same positions, but were interpreting different orders. TLDR, we did our homework, they didn't. Bonus TLDR, Venezuelan courts are. Story 14, a guy I used to work with was going through a messy divorce about 20 years ago now. His soon-to-be ex-wife was a psycho, and her father was a psychologist, so he was pulling all of the strings, even had my coworker arrested at work one day, BS charges. The divorce case took years, one young son involved, and at every turn, my friend lost because of something the father filed or another string he pulled. In the end, they were in court, and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was squashed, and he was mentally broken. The judge asked the ex-wife if she had anything else to add, and she said she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case, and she said yes. The judge turned to my friend and said, paraphrasing Mr. XXXX, all these years and all these claims that I ruled against you, the court profusely apologizes. I did not believe you, but now I do. Ruling in your favor bangs the gavel. I grant you full legal and physical custody of your minor child. Bailiff, please handcuff Miss XXXX. My buddy was stunned that he won and happy at the same time. He later found out that the note said, give me my son or he'll kill you. Story 15, obligatory INL. but I am a certified paralegal. I went to court and spoke for a friend at hearing. I can ask questions to both parties and address the judge. The only thing I can't do is object to the other lawyer's line of questioning. So hey Race, what happened? Best male friend was fighting a restraining order against him by his crazy ex-GF. Everyone was in the courtroom that day, including her. Her lawyer questioned Mai about their relationship. As an aside, they lived together. He moved out and got his own place, but they were still together. She just got obsessively crazier to the point where they broke up. She wanted some stuff back that she gifted him, and he refused to let her in while not home to get it. She got crazy angry and made a scene in his front yard, getting cops called and the neighbor's dog taken for being a pit bull in a park where they were not allowed. Bullshit, I know. Next thing you know, she's got a restraining order on his mom, who lived right next door to her son, and is trying to get one on him and sue him for his back. So when he's on the stand, questioning him about the incident about her showing up and trying to break in, his mother called him the moment she saw her banging on the door. So he beat the police there. She had gotten in and was in the living room. I asked him if he was in fear of her, and he says absolutely, because upon waking in, she slid an iron bar from her sweatshirt sleeve, telling him to back off. He was just standing there, mouth open wide and shocked. He returned on the stand. I asked her about the day, if she had gotten in. She insisted she did via a key, which we knew was a lie. She never had a key. So then I asked her about the iron bar. Why did you have it? Where did it come from? My cop friend gave it to me to protect myself while driving from road rage. It's in my car all the time, so I just brought it with me in case anyone was inside that wanted to mess with me. And did you have it up your sleeve? Yeah, because I didn't want neighbors to think I was breaking stuff. She was bawling and slamming her fists in her thighs and pulling her own hair. Wailing, I rested after that. She admitted to trespassing while carrying a concealed weapon. Both restraining orders rescinded. She was asked to stay after court was adjourned, and the judge handed her mandatory therapy and committed her for observation. Yushana. Edit major thanks to you, dear occupant. He's helped with the law for all. If your suspicious idiocy's a lawyer, I know, but my parents were in a lawsuit where this happened. They own a business, and on either side of it were businesses as well. Their neighbor to the left sued us, claiming that we had been using their property without paying them or without permission, that we were essentially trying to adverse possess it. We got a surveyor to come in, and the surveyor said that not only were we using all of our property, but we had been paying rent to them on about 20 feet that was also our property. Obviously, they weren't happy. So they got their own surveyor, who gave us 50 feet. We won the lawsuit. Now, their little patch of property has a rusty fence all around it with keep-out signs everywhere. It's about 20 by 10 feet. Story 16, when I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel, basically saying that the old lawyer didn't do his job. So we prepare an argument based on not asking the right questions, not communicating, etc. We think it's going to be a tough case, but not unwinnable. Then we get the response to our complaint, where the old lawyer argues that he was only ineffective because he didn't have time to prepare for the case and only reviewed it the morning of the original trial. He had known about the case for months, by the way. The judge saw this, and during the trial we had essentially asked, isn't this the definition of ineffective counsel? Not giving enough time to your client. The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer than that. Thanks, opposing counsel. I guess you were ineffective for both of you. Story 17, not a lawyer, but in a suit against an employee, her attorney presented our contract, and their contract to demonstrate the differences to prove that his client hadn't stolen ours. Then where did you get our contract, dumbasses? We won. Spent a couple $100,000. Defendants both ordered to pay $10K, filed bankruptcy, and dissolved business. Started anew with another competitor. Life. Story 18, I am a lawyer, but this was from my time as a law clerk, tattoo artist, around 40, gets charged with rape of an employee. The victim is 17, very fragile and barely able to sit in the same room as the defendant. She stares at the table the entire time, and you are barely able to hear her speak. She does not elaborate much on details, but basically he forced himself on her after closing the shop for the day. The defendant's story is that the employee came on to him and that there was consensual. The defense calls a witness, another employee at the same shop, to basically tell everyone what a stand-up guy the defendant was. If I were to guess, I think the court were undecided, but maybe leaning on a not guilty verdict up until this point. The defense witness takes the stand, starts telling a story of how the defendant, while doing a tattoo on her, tried to hold her down and kiss her, but had to stop because someone else came into the shop. Game over. Perp got convicted of rape. A week later, he declared that he was satisfied with the penalty and chose not to appeal. Edit, just to clarify, since many comments are based on U.S. law, this happened in Sweden. Story 19, not a lawyer, but I am a former insurance fraud investigator. We were at a hearing before the WCB. I had something like 18 hours of video spread over a 2-week period of a claimant doing roofing work. The problem, for me, was that the video didn't get a clear face shot. Normally what we like to do was get in close, show the face for a positive identification, and then zoom out. Bonus if the claimant was wearing distinctive clothing that could easily be tied to him. Because of where this guy lived, all I could do was show someone who matched his description getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing. So the company lawyer is prepping me and basically letting me know to be on point, because the claimant's attorney is almost certainly going to challenge the fact that it is his client in the video. If the video got tossed, the case was lost. About 2 minutes into the hearing, claimant's attorney agrees to stipulate to the fact that it is his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only leg he had to stand on. Claimant attorney was incredibly smug right after this, like it was no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer, since he was doing the roof the wrong way. He tried to get me to answer questions about roofing. I refused as it was beyond the scope of my work, and he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated numerous times and under oath that he cannot work. Whether he's doing it for free, for cash, or for fun has no bearing on the fact that he's doing roofing work while collecting compensation benefits, which he was awarded because he couldn't do roofing work. The guy lost and had to repay a bunch of benefits." After a few of those hearings, I began formulating a list of lawyers I would never hire and ones I would absolutely want on my side. Story 20 IEL sued a trucking company for underpayment of wages. They claimed they paid by route and not by the hour, despite doing their payroll by the hour, because they had a USPS subcontract that supposedly told them to pay by the route. Defense calls the owner of the business to the stand and questions her about the contract, which is clearly incomplete. She explains that the company gets a new subcontract every 4 years. Without fail on cross, I flip to the first page of the contract and read the date, which is in the spring of 2011. Q, did I read that correctly? Eyes. Q, and you get a new contract every 4 years. Eyes. Q, so you get a new one around the same time in 2015. Eyes. Q, and why you haven't produced that contract today? I haven't seen in years, but it's the same thing. Q, where does this contract tell you to pay your drivers by the route? When she can't answer, I follow up with, and the 2015 contract that we don't have says the same thing. My client started working for them at the end of 2015. Their whole argument was based on a contract they couldn't find. We won. Story 21. I've got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they were not part of our yard, the tree was owned by my parents, and they were responsible for it. Some guy tripped over a branch and was seriously injured. He came after my parents for all of the money. The dude showed up with a mountain of evidence, hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently, his lawyer brandished this stuff like a bat before court. My parents' lawyer thought he had a good case. Until the first day of court, when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief. "No, that's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started screaming at his client. "You said that was their tree." Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All's well that ends well. Edit INL, obviously, but neither are most of these commenters, so I thought it was all right. Story 22 IEL. Not my case, but I was in the courtroom watching a trial. Pro SE defendant who was accused of flashing a guard and masturbating till, well, as a pro SE defendant, he defended himself at trial without an attorney. Prosecutor was doing well proving the case. When a female deputy was on the stand, the defendant asked her one question: "If you saw me do what you claim I did, then how big is my?" The deputy responded by raising her hands and estimated about 15 inches. The guy grinned, turned to the jury, nodded, said, "Yeah, that's right," and sat down. Obviously, he was convicted. He was doing a 10-year prison sentence. So this conviction wasn't of much consequence, but he'll never forget it. Edit clarification, re-pro SE. Story 23 accidentally proved. Not often. Made tactical errors. Often arguing a case on a voter recount in front of judge. Judge says, "I'm going with X, that's in my favor." So I shut up. Opposing counsel, and arguing a different point later, suddenly goes back to the earlier point and belabors it. Client, also a lawyer, says to me, "Don't say anything." I whisper back, Don't worry, wasn't planning to. Judge begins rubbing his nose and looking irritated. After a few minutes, cuts off opposing counsel, saying, I already ruled on this point. Mr. Smith, anything to add? I replied in the negative and won my motion. Would it have come out differently? I don't know. Did opposing counsel make it easier for me? Absolutely. Story 24, my opposing counsel made some off-the-cuff remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or the records-keeping process. In the jurisdiction we were in, records were exception to hearsay rule, but you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records and won. All because the opposing counsel complained that their witnesses had to go way out of their way to get records for the court. Story 25, domestic violence case where the husband beat the wife senseless. Landlord tried to evict wife for breach of lease due to the beating. Landlord claimed wife violated lease terms by allowing police to be called to property and causing a disruption. My argument was that as a domestic violence victim, wife is covered under VAWA and the property is HUD subsidized. Also, MD law offers DV protections too. Landlord's counsel, during his opening, talked about how my client was beaten and the police were called and an ambulance, etc. I just stood there looking at him. When he finished, judge asked if I had anything to say. My response, no, Your Honor, I believe opposing counsel has said everything that needs to be said. Judge smiled and ruled in my client's favor. Landlord can't evict DV victim. Story 26, my public defender wife, not a Redditor or ID, get her to speak for herself, was trying a case where the defendant was accused of filling fraudulent prescriptions. Now, keep in mind PDs deal with a lot of shady characters who maintain their innocence with increasingly implausible stories as the evidence gets worse, so you can get a bit jaded after a while, but you don't have to believe your client's story to represent them vigorously. So the prosecution has grainy surveillance video of someone who looks like the defendant getting the prescription filled and the ID used to fill it, which belongs to the defendant. Defendant maintains that someone stole his ID and is using it because they look similar but never reported the ID as stolen. Wife is skeptical that the jury will go for that, but she's always willing to go to trial if that's what the client wants, so preps that defense and heads in a trial. Prosecutor brings in the pharmacist who reported the prescription issue, goes through the usual routine of establishing who she is, where she works, was this the ID used that day, etc. Finally, the prosecutor asks the pharmacist if the person who attempted to fill the prescription that day is in the courtroom. No. Oops, edit grammar clarity. Story 27, parents were being sued by their landlord, and parents had a countersuit against them. Parents were moving across country and found this house to rent. They did a walkthrough, looks great. Landlord wants first, last, security, and $1,500 because they had a dog and 2 cats. Fine, it was somewhere in the $800 to $900 range. No big deal for them. They're set to move in on a Monday, so my mom flies in on Saturday to do one final look over, sign the contract, and get the key. Perfect, they are now the tenants. Monday they arrive, and the house is trashed. The landlord has moved a bunch of his stuff into the garage, shed, and one of the bedrooms. There's in the toilet on the floor, garbage laying everywhere. Used condoms. I can't really do this justice, but my mom took pictures and videos throughout the entire house. She calls the landlord and tells him that they are not moving in with the house in this condition. He tells her to clean the house. And hell, by the first tank of oil for the house, it was empty. He tells her to do it. Or he's keeping all the money for breach of contract. A lot of back and forth happens, and tons of harassing texts and phone calls from him. Court day comes, and everyone's ready to submit their evidence in front of the judge. Parents have photos, texts, the contract, videos. Landlord only has the contract, but his contract is different than my parents'. He's included a section that states they permit him access to the house for his storage needs, and that tenant is responsible for all on-site cleanup and maintenance after accepting the key. The best part was that the date of the signatures on his contract was the date they moved in, not the date my mom flew in and signed. Judge tells the landlord he's a special level of stupid, and then the judge's final remarks were about how disrespectful the landlord was to show up in shorts, a Hawaiian shirt, and flip-flops in his courtroom. He never paid a dime, then claimed bankruptcy, and started a business under a different name. 2 years later, I went to his house, let out all but 19 PSI from all his tires, and superglued the caps on the valve stems. Story 28, my ex-girlfriend's father had a case where he brought in a decoy defendant. He then asked a key witness for the prosecution to identify the suspect in the middle of court. The witness turned and pointed to the decoy defendant, who was just a buddy of my ex-girlfriend's father and had nothing to do with the case. The witness was caught lying with his pants down, and the whole thing was hilariously embarrassing for the prosecution. Turns out, even if you're right, it's a huge no-no to trick witnesses like this. My ex-girlfriend's father had to go through an ethics investigation and was suspended from trying cases for a while. Edit to those asking why it was a no-no. I have no idea, but apparently he violated a couple of court procedures and broke a state law. An actual lawyer might be able to comment more on it. I assume there's some law that the real defendant has to actually be at his own court date, and you can't have a proxy maybe. Story 29, when I first started practicing, I handled a custody case where my client mom had a problem with dad smoking around the kids. I asked him if he regularly smoked around the kids, to which he replied that he doesn't smoke tobacco, only weed in the house. Obviously, this raised eyebrows, as it is illegal in my state. He then went into a long diatribe about how he only follows the law of the streets. He actually said this and doesn't recognize the authority of the court he was currently in front of. Needless to say, mom got full custody, especially after dad was arrested for going to the court services officer's house late at night and trying to kick her door in. Story 30 in AL. But work with lots. We deal with car accidents. And this particular girl was claiming severe whiplash and lower back injuries from a minor rear-end accident. Some of her injuries were legitimate, but she was claiming that her life was ruined and she was unable to function in society. She worked as a physical therapy aide studying to become a PT. So she knew just what to say, but she didn't know what not to post on Facebook. She claimed she was in constant pain after the accident and couldn't go to the gym. The day after the accident, there's a pic of her lifting weights, #accident, can't hold me back. She claimed a month of lost wages, but there she is in a patient graduation from treatment photo on her work's website the week after the accident. She missed 0 days of work. She claimed that she couldn't travel anymore, and guess who had photos of Vegas strippers all over her Instagram for her sister's 21st birthday? She asked for $200K, and she got $9K for the legitimate injuries and mediation, as the mediator laughed at her Facebook feed.